Welcome, dear friends. I extend my warm greetings to all of you. Even before I begin on this topic, I must express my deep appreciation to the MADRAS Bar Association and to MBA Academy for having organized this series of lectures on various important topics for the benefit of the advocate community at large. The topic today assigned to me is Appreciation of Evidence in Criminal Cases. It's a wide enough topic, and I hope that I would be doing justice to the said topic. Under section 154 of the Code of Criminal Procedure, information in cognizable cases must be given to the police station, and they should be reduced in writing by the officer in charge. This is normally called the first information report. Investigation commences based on the said information given to the police official. This leads on to completion of investigation and the filing of a final report under section 173 CRPC. Thereafter, the procedure under section 207 CRPC has to be complied with, and the accused has to be given a copy of the final report, also called the police report, and of all other documents which the investigation authority relies on. Under section 209 CRPC, if the magistrate finds and holds that the offence made out is triable exclusively by a court of sessions, then the accused is committed to the court of sessions. Otherwise, if it is a warrant case triable by a magistrate, then under section 240 of the Code of Criminal Procedure, the magistrate can proceed to frame charges. When it is committed before a court of sessions and the accused appears before a court of sessions, as advocates for the defense and as advocates in the office of the public prosecutor, it is your bounden duty to insist that the sessions court follows the procedure envisaged under section 226 CRPC. This is a procedure rarely done. In fact, very rarely done. But it is a very important step wherein both the court and also the counsels know as to what is the nature of the case and what is the evidence produced by the prosecution to substantiate the case, the charges. 226 CRPC, and I hope that you would be having a copy of the Code of Criminal Procedure and the Evidence Act and the IPC here in front of you, reads as follows. It is about the opening case for prosecution. This is a very important step. According to section 226 CRPC, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused. If upon considering the records of the case and documents, the Court of Sessions decides to discharge the accused, it is a different issue. But if the Court of Sessions proceeds to frame the charge under section 228 CRPC, then the accused must be put on notice of the charges, and his plea, whether he pleads guilty or not, should be recorded. Now, I will pause here for a minute. This is the stage when, as counsels for the accused, when you have been furnished with a copy of the documents relied on by the prosecution, copy is given under section 207 CRPC, you will find to be in possession of a sheaf of papers starting from the first information report and ending with the final report of the investigating officer. Now, the evidentiary value of all these documents will have to be examined. You will also be given a list of witnesses, and you will also be informed as to the nature of evidence which each witness proposes to depose. With these materials in hand, appreciation of evidence before the trial commences, the first step is for you to examine these documents in its proper perspective. Under section 226, when the prosecution opens the case, it would be very ideal if the prosecutor insists upon the presence of the investigating officer. A cogent narration of the facts and a cogent narration of the evidence gathered by the investigating officer can be presented to the court. The list of witnesses and the evidence that they propose to speak about can also be informed to the court. The defense counsel will also be made aware of all these facts. The presence of an investigating officer at that preliminary stage is essential. This throws up further questions, and even before I proceed further on this topic, I would invite the members of the bar to examine one further ticklish question, which, to the extent possible, I have done some research, has been left unanswered, though answered and answered differently in two different cases. That is, the presence of the investigating officer during the course of the trial when the witnesses are examined. There had been two occasions when learned single judges of the Kerala High Court and Delhi High Court had occasion to examine objections raised for the presence of the investigating officer during the examination of other witnesses. There is a normal rule which is followed both in criminal trials and also in civil trials. The witnesses who are to be examined subsequently are not permitted to remain within the court hall. They are asked to stay outside. Now, this is not a procedure envisaged under the Code of Criminal Procedure. It is not a procedure given under the rules of practice. Now, where did this practice come about? In AAR 1960, I am not going to give you too many judgments on the topic in which I am going to dwell on, but there are a few judgments which are very interesting and which have set the course of the appreciation of evidence in motion. Insofar as presence of investigating officer, there are arguments for and against it. If an investigating officer is present, the defense counsel can very well say that witnesses to be examined might feel intimidated and might not tell the actual truth or what they want to say under oath. On the other hand, the prosecution may also say that there is a duty cast on the investigating officer to be present during the course of trial. There are two views on this, and it is open to the bar to examine both the views and take it up in appropriate proceedings. The first view was expressed, as I said earlier, in AAR 1966 Kerala, page 316, Dr. Kashi Iyer versus State of Kerala. Justice V.R. Krishna Iyer was the advocate for the accused in that case. He moved a motion stating that during the course of the examination of the witnesses, the presence of the investigating officer should not be allowed by the Sessions Court. This came up for consideration before a learned single judge, Justice P. Govinda Menon. The learned single judge examined the theoretical concepts laid down in the Halsbury's Laws of England and stated that the sessions judge is well within his powers to call upon the investigating officer not to be present when other witnesses are being examined. But the final judgment did not specify about only the investigating officer. The conclusion was that witnesses subsequently to be examined should not be present. That was the rule which is still being followed. But while doing a little more research, I came across an unreported judgment of the Delhi High Court dated 14/2/2012 in Rajiv B. Agarwal versus the CBI in two writ petitions. Writ petition criminal number 30 of 2012 and writ petition criminal number 32 of 2012. Learned single judge Justice M.L. Mehta referred to an earlier judgment of the Supreme Court and which is reported in JT Judgment Today 2001 10 Supreme Court page 111 Shailendra Kumar versus State of Bihar, wherein the Honorable Supreme Court had observed that the investigating officer has a duty to be present in court, and the learned single judge of the Delhi High Court stated that he does not find anything wrong in the noting of the sessions judge who permitted the investigating officer and the associate investigating officer to be present during the examination of witnesses. Even though we may feel that the Supreme Court had given a final pronouncement on the said subject, still it is open for further discussion and debate. Quite apart from this, when the stage comes to examination of witnesses, one further judgment of the Supreme Court should be always read and reread by the counsels, both on the side of the prosecution and on the side of the defense, before actual oral examination commences. This is a classic judgment. It is Vadivel Thevar versus State of Madras, AAR 1957 Supreme Court, page 614. The Honorable Supreme Court had laid down three categories of witnesses. Witnesses who are wholly reliable, no corroboration is required. Witnesses who are wholly unreliable, no corroboration is required since it has to be rejected. Witnesses who are partly reliable and partly unreliable. For these witnesses, corroboration of their statements is required. The counsels may keep this judgment in mind before commencement of the trial. When you categorize the list of witnesses, you should make a mental note of the gist of the evidence which you can find out from the documents which had been supplied, and make a point as to which is the evidence of the witness, which witness you are going to exploit and attack during cross-examination. Prosecution, on the same hand, should also make a note as to who is the star witness for the prosecution, who they feel is required to depose to establish the guilt of the accused. Now, after this process commences, when the prosecution has opened the case, and when the judge has framed the charges, and when the accused has denied the charges, then the commencement of examination of witnesses begin. The preliminary witnesses will be speaking about the incident itself. It starts with the complaint given to the police. That is the complaint I was referring to in section 154 of the Code of Criminal Procedure, which had been reduced in writing by the police official. In short, the first information report. The complainant, the de facto complainant, could be a victim of an offense, could also be a relative of a victim. We will now take up a few instances. Let us take, for example, a charge of bribery against a government official, be it a state government official or a central government official. Now, when there is a demand of bribe, of illegal gratification, the victim gives information about the demand, and later his statement is recorded and it becomes a complaint, and he is called a de facto complainant. He is examined in court. He will have to depose about the circumstances surrounding demand in the first instance. No other witness can be produced by the prosecution unless they have direct knowledge of such demand to prove the demand of bribe by the accused. The other witnesses in cases of that nature would be about acceptance and recovery if it is made out by the investigating officer during the trap process. Let us take, for example, a child witness or a lady witness, a victim of physical assault or sexual assault. Now, the counsel for the defense and the prosecution should be very careful in handling such witnesses. They are deeply injured. They had suffered injury. They had suffered not only physical injury, but the violence has left a mental mark in their minds. Now, this is one category of witnesses who will be speaking about the complaint. If it is a case of homicide, then there is going to be an eyewitness who will speak about the actual occurrence. Now, occurrence could have been preceded by any further, a few further acts. There have been instances when there is a witness who sees a group of people chasing the deceased in the first instance. The deceased runs. These witnesses only see the chasing aspect of it. Another group of persons or an eyewitness might actually see the commission of the offense, which leads to a charge under section 302 IPC. Now, the counsel for defense must find out the nature and scope of the evidence which these witnesses can depose. To what extent can they go towards establishing the guilt of the accused? These are all complainants. We will also have cases where there are initially a complaint of man missing is given, and later a body is found out and identified, and thereafter a charge is laid. Initially, the police would register the case under section 174 CRPC, and then a man missing, and then alter it to 174, and thereafter, after investigation, bring about necessary charges, probably under section 302 IPC. Now, the complainant who initially gives about man missing or a girl missing may not know that what had happened to the unfortunate deceased person during the interregnum period. So then the evidence which they are going to state is not going to be about the occurrence, but about the fact that a person went missing, close to them, went missing from a particular day. Now, evidence on these on offences of this nature would revolve around circumstances. I will be dealing with circumstantial evidence and its appreciation also a little later on. Quite apart from the eyewitnesses and other witnesses who have some nexus with the actual offense, prosecution will also be bringing in what they call independent witnesses. Now, who are independent witnesses? Independent witnesses can be very simply defined as witnesses who are not dependent on the police for their survival. Prosecution will have them, if I go back to the illustration of the trap case, a bribery demand case, prosecution will bring about two witnesses whom they will say as independent witnesses to witness the actual demand, actual handing over of the money, demand at that particular time, the handing over and acceptance of the bribe amount, and the subsequent recovery of the money, if the trap laying operation goes according to the prosecution successfully. Now these are two witnesses who have no direct nexus with the offense, but they are there to witness the occurrence. You also have a category of witnesses who are present and produced by the prosecution who have witnessed recovery. In narcotics cases, NDPS cases, recovery of the substance. Very important witnesses, there must be independent witnesses to speak about the actual recovery. You also have witnesses categorized as independent witnesses who will be witnesses to confessions by the police. And you may also have witnesses categorized as independent witnesses who are present when the investigating officer prepares a mahazar, a spot inspection, a diagram, a sketch, and recovers any material object from the place, either through information or otherwise, through his investigation. So these are all independent witnesses, and for the prosecution, they are very material witnesses to vouchsafe for the recovery, to vouchsafe for the sketch which had been drawn by the investigating officer. The other types of witnesses are the official witnesses. I am broadly categorizing them. Official witnesses. These will begin with doctors who have examined witnesses, forensic lab authorities who have examined any of the objects transferred or sent over to the forensic laboratory for analysis, and of course the police officials. The police officials will also include the official who actually recorded the first information report, and also the investigating officer. They are a broad category of witnesses who will be coming forward to depose in a court of law, and the prosecution will have to have its own strategy while examining these witnesses, leading them through the chief examination, and the defense counsel will have their work cut out during cross-examination. I would urge that any advocate who is interested in taking up criminal law as a practice must have very deep knowledge about human psychology and about forensic science and forensic medicine. Very important. You will always have, you may on occasions have what is called death by drowning. Now the issue would be whether it is ante-mortem drowning or post-mortem drowning, or simply drowning before death or after death. Whether death had occurred elsewhere and the body was then put into the lake or a river or wherever it was recovered from, or whether the person was alive and then drowned while alive. You will also have cases of burning, whether the person was burnt while alive or burnt after commission of murder. You will also have cases of asphyxiation, smoldering, whether it was done prior or later. You will also have cases of hanging, whether hanging was done later after the death of the person, whether the body was hanged or whether it was hanged while he was alive, forcefully. Now, unless you know about forensic science, you will not be able to know the difference which is evident in a body in all these cases. If a person is alive and then drowned forcefully, naturally his senses will be working and he will swallow or gulp the water in the place where he is drowned. So that water will enter the throat and into the stomach. During post-mortem, this can be found out. If it is a case of burning, if he had been alive while he was burnt, then he would have inhaled the smoke and there would be particles of soot or other materials which had been used, small smell of petrol or kerosene in the trachea, and that can be a good indication of finding out whether he was alive or whether he was dead during the course of burning. A dead body, when it is burnt, will give out white fluid. There will not be red marks on it. If it is a case of hanging, again it can be found out by examination by a doctor whether the hanging was before or after death. Please have a thorough reading of forensic science and forensic medicine. Have a thorough knowledge of which poison affects which part of the body. Have a thorough knowledge of what injuries each weapon causes. If death is caused by a bullet wound, whether it was a long range or whether it was short range. If it had been shot at very close range, you will find the marks of the bullet, the marks coming out, the soot or other small splinters coming out in the body. If it is a long range, it will only enter into the body from a distance. The bullet will enter into it. You will be able to find all these differences if you have a reading about forensic science and forensic medicine. This is very important. As a matter of fact, I have been informed, and I tried to do some research and get some papers on this, but unfortunately I have not been able to do it. But much prior to when it was Madras presidency, prior to independence, there was an order passed by the then government prior to independence that any advocate with about 5 years standing can witness a post-mortem. Not the post-mortem of the particular client, of a post-mortem of the dead body in which he is interested in defending the accused, but any post-mortem to know about the anatomy of the body. But now I had contacted a few of the deans of the medical college, and they say that there is no such government order prevalent today. The Bar Association can take this issue also. When we as judicial officers, I entered service as a district judge. We were given training to witness postmortems, to find out how exactly each nature of death, what are the injuries which are caused inside the body. A contusion injury, for example, will have a swelling inside the skin, may not be visible outside. So these are all instances which you will have to have a thorough knowledge about. And this is required when experts come in for cross-examination. Now I think I am going away from the topic on all those issues. But let me come back to evidence and its appreciation. Under 207 CRPC, you will be, as I said, given a bunch of papers, and you will have to form an opinion about its admissibility and other aspects about each one of the papers. Now, what are the papers which might be given under section 207 CRPC? The first one, of course, naturally will be the complaint and the first information report. The first information report is not a substantial piece of evidence. It cannot be used for any other purpose except as a fact that police had been received with information regarding the occurrence of a cognizable offense. But as prosecutor and as counsel for defense, you will have to examine two aspects in a first information report. The first aspect is whether there has been a delay in lodging the first information report. In giving information in the first instance itself, delay from the date of occurrence to the date of knowledge, to the date of lodging of the first information report. This delay will have to be explained by the complainant, and counsel for defense can exploit that explanation. There can be a second aspect of a delay. The delay occurred by the police in submitting this first information report to the magistrate court. That explanation will have to be given by the police authorities. Now these are all two aspects, and you may have occasion to read the judgments on what are the plausible explanations given on various occasions, what nature of explanations are acceptable by court. But please remember, those explanations which you read in a judgment either of the High Court or of the Supreme Court are based on evidence. That explanation has been given in a witness box by a witness, has been deposed by a witness, giving the nature of explanation. And the appellate court, either the High Court or the Supreme Court, the report of which you are reading, has weighed that explanation. That explanation has to be weighed with the examination in chief in support of that, with the cross-examination on that explanation, on the reasons given. So you will have to deeply question the reasons given. On receipt of the first information report, please put yourself in the position of a police official who receives information about a cognizable offense. Let us take it as a homicide. Then he goes to the place, to the scene of occurrence. In the first instance, if the body is available there, he prepares what is called an inquest report. An inquest report is a preliminary examination about the circumstances surrounding the death, about what actually is found on the body, what are the nature of injuries. It is not a conclusive evidence. The police official's investigation does not end with an inquest report. It has no evidentiary value. It is only a starting point for the investigating officer. He has several witnesses surrounding him and he asks them, how did this happen? Do you have any explanation? Do you know, any of you know about it? Statements, what are stated are recorded by the police official and signatures are obtained. This is the inquest report which you will find in the group of papers given to you under section 207 CRPC. You will also find that subsequently the investigating officer, when he takes up investigation further, records statements of witnesses. He records their statement and the provision under which he records is 161 CRPC. Now we call these as very loosely as 161 statements. They are not admissible in any court of law. They cannot be used by the prosecution. They cannot be marked by a judge. They cannot be produced as evidence. But they form the basis. They tell that this witness is going to say something somewhere on these lines. And this is the statement recorded by the investigating officer. There is a bar in the provision itself. If you go through, you'll have to go through section 161 and sections 162 subclause 1 of the Code of Criminal Procedure to find out about the evidentiary value about this. And you will find that it should not also be signed by the person who makes it, who gives the statement. You will have a bunch of statements. This 161 statement, which you will be having of various witnesses, can be used only for a limited purpose of contradicting the maker in the manner laid down in the proviso to section 162 subclause 1 of the Code of Criminal Procedure. Independently, they cannot be used for any other purpose. It is a statement of the witness recorded in court under oath, which you as counsel for defendant or for the accused will have to question and cross-examine. You will also find statements recorded under section 164 CRPC. Have a look at section 164 CRPC. 164 has two parts. The magistrate may record confessions under section 164 CRPC. I'll come about confessions later. He can also record statements under section 164 CRPC. It is only a statement under 164 CRPC and can be used for contradiction or corroboration. I'll put it the other way around, corroboration or contradiction. Now, this is broadly the evidentiary value of statements recorded by the police official under sections 161 and 164. There are innumerable judgments on that. If I were to pick up one, I will have a doubt as to why I did not pick up the other, but I would invite you to do some research on these aspects and take care to ensure that the court does not let in 161 statements as being admissible or that refers to it in the course of its judgment. Quite apart from all this, you will also have confession statements. Now, confessions, as stated above, can be judicial, recorded under section 164 CRPC, may also be extrajudicial confessions. A confession recorded under section 164 CRPC is called a judicial confession. Confession recorded by any other person other than a judicial magistrate may be called as an extrajudicial confession. When you have in your hands an extrajudicial confession, the counsel for the accused will have to examine as to the relationship between the accused and this person in whom he has confided so many aspects, as to whom he had confided the nature of the offense, as to whom he had confided the commission of the offense. First, you will have to verify the antecedents of the person who has recorded the extrajudicial confession, whether it is probable that the accused will go to him and confess to him. You will have to attack the witness on that aspect and also on the reliability of the confession, the extent to which it could be used as a piece of evidence by a court while in its judgment while deciding the charges framed against the accused. There are again several judgments on these aspects. The courts have quite often examined into it, but I do not want to reduce this lecture of mine into something as giving judgments and then asking you to examine, but every criminal case has to be decided on the facts of that particular case. Keep broad principles in mind. You will also find confessions of a co-accused, and you will also find confessions of a co-accused being retracted. Now, these are situations you will have to handle during the course of trial. If it is retracted, ensure that it is brought to the notice of the court, that the court gives a finding on its evidentiary value, on the confession and on the retracted version. So you have a task cut out in your hands while they're deciding about the evidentiary value of confessions. While talking about confessions, we will also have to talk about section 27 of the Evidence Act. Now, very loosely we've been taught in college that no confession recorded by a police officer is admissible in evidence except that part which leads to a discovery. Now, I will insist and I will very fervently request the participants here to kindly read AAR 1947 Privy Council, page 67, Pulukuri Kottaya versus Emperor. No discussion on section 27 of the Evidence Act can either begin, end, or be narrated without reference to this judgment. It is a classic in itself. There were about 4 or 5 accused facing death sentence, and 2 of them have been also facing transportation of life. It was serious punishment imposed, sentence imposed by the High Court, and their last gasp appeal was before the Privy Council. 2 aspects were taken before the Privy Council. It was a case of a group of people going and committing murder. It happens. 2 aspects were taken up before the Privy Council. One was non-furnishing of documents Privy Council examined that but did not accept the contentions of the appellant on that. The second aspect was marking of portions of a confession which, according to the counsels for the appellant, and which the Privy Council upheld as true and correct, inadmissible portions of the confession. Both prosecution and the counsels for the accused should keep this in mind, should read this judgment. They say a very strange fact. They say a statement: if you come with me, I can show you a knife which I have hid in the which I have kept in the roof of my house. Now, Privy Council states that that is not a discovery of a fact. A knife had been discovered long back. Unless it is relevant to the offense. Unless it is relevant to the offense, that portion of discovery which leads to such discovery of a fact known to the accused, exclusive knowledge of the accused, that portion alone can be marked as evidence, as admissible. The accused may say, I stabbed him. It is not relevant. It is not admissible. Please read this judgment. The subsequent judgments also. Section 27, the discussion has to revolve around AR 1947, Privy Council, page 67, Pulukuri Kottaya versus Emperor. I have given very inadequate explanation about the said judgment, primarily because I would like each one of you to examine the judgment in full. You may also have a dying declaration among the bunch of papers given to you. Now, sanctity of a dying declaration has been upheld by the courts of law. In this connection, the magistrate records a dying declaration. This is a normal occurrence is that once a victim or with deep injuries is admitted to a hospital, a report is sent by the authority, by the hospital authorities. It becomes a medico-legal case, and information is given to the local police, and quite often the police also seeks the assistance of a magistrate to record what is called a dying declaration. Now, magistrate goes and records a dying declaration. It could be an instance of burning. It could be an instance of a deep injury and the person still surviving. And there is an imminent possibility that he may not, God forbid, survive. Now, five judges of the Supreme Court sat together, and I would request you to examine this judgment also. There were I'll be going through just 2 or 3 further judgments, but with respect to dying declaration, 2002 SCC criminal, page 1491, Lakshman versus State of Maharashtra. Now here a judicial magistrate went to the hospital to record a dying declaration. The issue was whether a certificate is required from a doctor to certify that the person, that the unfortunate victim was in a position to give a dying declaration or not, to give a statement or not. There were 2 contradictory views by the Supreme Court, 3 judges, two different views. And the Constitution bench, a full bench was set up to resolve that issue. Please have a look at it. They have gone through the status, the satisfaction as to whether he is fit enough to give a dying declaration, a statement, and the truthfulness of the statement. Have a look at that judgment, and I'll throw it open for your own debate among your own circle. There are various judgments on dying declarations. You will also find multiple dying declarations, the same person saying a different story again. It happens. Judicial officers who are listening to this small lecture by me will have first-hand information about the families of both the victim and the accused surrounding, and making it impossible to have a situation to record a dying declaration. And I must here comment and inform the advocates the extremely difficult position in which magistrates are put when recording dying declarations. It happens normally in the middle of the night, and they have to go there and record it. But these are circumstances you should know when you are defending your client, or when as prosecutor you are putting forward this piece of evidence for consideration of the court. Apart from dying declarations, you will also have to know about common intention and common object. Common intention and common object, there are two sections, section 34 and section 149 of the Indian Penal Code. Now, what is common intention and what is common object will be a discussion purely theoretical in nature. But it would be better if you read a judgment on that aspect, a very strange judgment, but by the Honorable Supreme Court. And they gave the difference between what is common intention and what is common object. And in this particular judgment, when the accused had been convicted under section 302, and the charge was under section 302 read with 149 IPC. Supreme Court at the end, the last end, they said that they convicted under section 302 read with 34 IPC. So naturally, when they have to come to that conclusion, they will have to discuss what common intention is and what is common object, and the differences, and why they are coming to that conclusion. That is why I picked up this judgment for your reference, which gives in quite clear terms the differences between common intention and common object. Please have a look at AAR 2003, Supreme Court, page 796. Chittarammal versus State of Rajasthan. A very interesting judgment. All these relate to homicide. This is in fact, it relates to double murder. And have a look at that judgment. And then you will also, once you go to common intention and common object, the next aspect naturally which comes to your mind is about conspiracy, 120B IPC. You will have to examine what are the ingredients about 120A, 120B IPC. And that is in fact a separate research aspect in itself, whether because conspiracy, they say, is done in secrecy, and you have to fish out conspiracy. But one aspect I would like to talk about is about the train theory, where one conspirator gets into does one portion of the act, comes out, the other person takes over, comes out, and the third person takes over. So have a look at the Rajiv Gandhi assassination case judgment, and that will give you much light on this train theory. A very interesting judgment. And those of you who have read it in newspapers, or who are now interested in knowing about it, look at it. Excellent judgment given on going into various aspects of criminal law. Quite apart from all this, you will also have test identification parade, a report about that. Now what is this test identification parade? Now somebody identifies the witness, the accused. Now you can also have the witness who had seen the occurrence identifying the accused for the first time in the court. Or it could be done prior, and a report may be drawn up in the presence of a magistrate that when he identifies the accused, when the accused is made to stand with other similarly looking or similarly dressed individuals. The evidentiary value of a test identification parade will have to be examined by you. It is not substantial, and but still the prosecution may rely on it. And when we now talk about identification, the further topic which has to be discussed is about digital evidence. We today have the CCTV cameras fixed everywhere, and accused are identified through the image captured in the CCTV cameras. Not only accused are identified, but a vehicle which is used for the purpose of a crime is also identified through an image captured through a CCTV camera. Now, digital evidence is electronic evidence is a separate topic in itself, and it requires very deep examination. There have been conflicting judgments on necessity under of a certificate under Section 65B of the Evidence Act to establish the source of the digital evidence produced before the court. Now, that is one aspect which counsels must work, because that is going to be the basis by the prosecution to bring home the guilt of the accused. And you should know much about the electronic evidence and its nuances as counsels for defendants, for the accused. You will also have what is called an opinion by an expert. Section 45 of the Evidence Act talks about opinion by an expert. How far can it be relied on? How far is it admissible? How far can a conviction be purely based on the opinion? If you look at a post-mortem certificate, at the end, you will find that the doctor who has done the post-mortem certificate has stated that a final opinion he awaits final opinion after getting inputs from the forensic laboratories, but gives a probable cause of death. The final opinion is not given. You will have handwriting experts. You will have ballistic experts. Now you also have DNA experts. You have fingerprint experts. The evidence regarding the admissibility and its reliability on each one of these evidences given by the experts in those fields will have to be thoroughly examined by you. Handwriting expert, as age goes by, the handwriting changes. A thumb impression is fixed, more reliable. DNA, scientific, more reliable. But again, you will have to examine as to the procedure in which it had been done. If I go back to the trap cases, in all cases, the notes which are handed over by the de facto complainant at the time of demand, which as instructed by the trap laying officer, will always contain phenolphthalein powder. Now, the science behind that is that if somebody handles phenolphthalein powder and dips his fingers in a sodium carbonate mixture, then the carbonate mixture becomes pink in color. And it is therefore held that this is the person who handled the notes. Now this is in theory. Now they take this to a forensic expert and find out, and he gives a report also pink in color, and what it is all about. And very rarely there is cross-examination on that aspect. And you can't do effective cross-examination unless you know the theory behind, or the physics, or whatever it is behind that phenolphthalein powder and the sodium carbonate solution. Why does it change color, and what is the effect? This chemical reaction of the phenolphthalein powder on sodium carbonate. Now these are all aspects which you have to necessarily know. I would also go into what is called circumstantial evidence, which is also produced before a court to drive home the guilt of an accused. Now, when examining circumstantial evidence, a chain will have to be there, an unbroken chain will have to be present. There is one judgment I would like you to read, and Padala Veera Reddy versus State of Andhra Pradesh, AAR 1990, Supreme Court, page 79. Now this is a very interesting case. In fact, all these cases which you read relating to commission of offences, criminal cases, the facts are quite interesting. You'll have to, if you have the inclination for that, you'll find reading becomes a habit, and deciphering the conclusion will also become quite natural to you. Now this again is a case based on quite strange facts. The girl was married at the age of 12. Later on there was a complaint by her of demand of dowry. In fact, she went to the extent of filing a civil case as against her father and brothers, stating that the property which is in their hands, actually also she has a share in that also. Now, in an intervening night, when the husband and his parents had gone to a marriage, or rather they stated that they had gone to a marriage, when they came back, they found the unfortunate wife lying dead in a chair. There were marks all over the body. And there was also a tin which gave the name of a poison lying next to it, next to the body. Now naturally suspicions arose, and the son and the two parents and one more accused were charged. Now Supreme Court examined the evidence once again, and the son and the two parents were the respondents before the Supreme Court. They were acquitted by the High Court, but the father of the girl, PW8, had taken the appeal before the Supreme Court. Please read this judgment. They examine about the circumstances surrounding the forceful pouring of poison, how the mouth should have been opened and poison should have been poured forcefully over the girl, and how injury should have been caused over the girl, over the unfortunate victim who had died. The conclusion is irrelevant, but the discussion on all these cases is very relevant to all of you. Have a look at that judgment on Padala Veera Reddy versus State of Andhra Pradesh, AR 1990, Supreme Court, page 79. You will also have to examine whether the accused had been inflicted with injuries and whether prosecution has satisfactorily explained the injuries. Now naturally, when accused has also suffered injuries, he could not have, hopefully or probably he could not have self-inflicted them on him, the injuries on himself. The prosecution has a duty to explain, and that is one aspect also wherein, as counsel for the accused, you can exploit that situation. And if there is no explanation given by the prosecution, then the accused can put it to his advantage. The conduct of witnesses and the conduct of the accused are also relevant. They are also relevant, and for that, now, though at the conclusion, I would now go back to Evidence Act. What is it in Evidence Act which are very important while determining appreciation of evidence? I am not going to go into every section, but please examine as to what is a fact, what is a relevant fact, and what are the facts in issue. Please examine what is proof, what is disproof, and what is not proved. These are given in section 3 of the Evidence Act. Come next to section 8 of the Evidence Act. Motive and the conduct before, subsequent are relevant. Come down to section 9 of the Evidence Act. And then go over to section 27 of the Evidence Act that talks about confession and the discovery of a fact. Go up to section 30. Don't just stop at 27, but also have 30, which deals with the confession of a co-accused. Go also to section 32 about dying declaration. The circumstances relating to the death must be given. And go over to section 45 about expert opinion. And then about examination of witnesses, the last part of it. These are the Evidence Act is an act which had seen very few amendments. What have been brought in as amendments are amendments relating to admissibility and otherwise of electronic or digital evidence. Substantially, proof has been the same. The nature of proof and the requirements for proof, the requirements for admissibility of a document, requirements for relevancy of a piece of evidence, requirements of what can be taken into consideration and what cannot be taken into consideration have been static right through. They have been interpreted in many ways earlier, but the fundamental aspect remain the same. With these few words, I will conclude this lecture. I hope it has been of some relevance to you. That is the word which I think I should use. But do further research on all these aspects. And before I conclude, I will also request one further, place a request before the learned members of the bar. Now, if you are, as a trial advocate, if your intention is to be in trial as a trial advocate, either in the civil side or in the criminal side, quite apart from having knowledge about all these aspects of all the law and all the procedure and all, you will also have to know human psychology. To understand human psychology, please have a grasp of various regional languages of this country. You can understand a witness if he comes from Andhra Pradesh unless you can converse with him in Telugu. You will be able to understand an accused if he is from Kerala and if you are to defend him unless you can converse with him in Malayalam. You'll have to get into the skin of the witnesses, get into the skin of the accused persons. You will have to know the nature of the scene of occurrence, the topography of the place. And that can be explained when you know the language of the place. You go there and visit and see the place. You have the destiny in your own hands. You do not have the confines of a rigorous structured education anymore. Your destiny is in your hands. Build it up. Build it up. Have love for languages. Have love for languages and have that inclination to understand witnesses, to understand accused. That can be done when you have a proper grip of the various regional languages of this country. As trial advocates, you will find that this will give immense confidence either from the accused persons or from any other, or their relatives, or from any other persons on your capabilities. A small conversation in their own language, mother tongue, will enhance your reputation. Take my word for it. And I would wish each and every one of you the very best in your profession. God bless you all. Thank you.